Hi, everyone. Welcome back to the 8th Harvard International Arbitration Conference. We're now at panel 3, Taking of Evidence in International Arbitration, Mix of Traditions. Let me very briefly introduce the speakers of this panel. So our first speaker here is Patricia Saiz. She's an arbitrator, a faculty member of ESAE Law School, and at the MITS, and member of the ICC International Court of Arbitration on behalf of Spain. She is also an officer of the IBA Arbitration Committee of Diversity and Inclusion. Before becoming an arbitrator, Professor Saiz practiced as counsel in the US for more than 10 years, and she's trained both in common law. Indeed, she's a 2003 Harvard Law School alumni, and in civil law, ESAE Law School in Barcelona. She is admitted to practice in New York, DC, and in Spain as well. Our second speaker here is Mr. James Hosking. He is the co-founder of Chaffetz Lindsay in New York and the head of the International Arbitration Group. Over the last 25 years, he has represented clients in more than 1,000 arbitrations and has sat in around 45 cases, acting as an arbitrator himself. Mr. Hosking's expertise is acknowledged by all major directories, and recently he was elected to the ICA Governing Board and as co-chair of the New York International Arbitration Center's Publications Committee. He's an adjunct professor at NYU Law School and co-author of A Guide to the ICR International Arbitration Rules, and he also, as Patricia, earned his LLM from Harvard Law School. Finally, we have Ari MacKinnon. He is the co-chair of Cleary Gottlieb's Global International Arbitration Practice, as well as the chair of the LATAM International Arbitration Practice. Mr. MacKinnon has been recognized as banded lawyer for or international arbitration by Chambers Latin America and Chambers Global. Latinvex has recently named Mr. MacKinnon one of Latin America's rising legal stars. He is a member of the board of directors and program committee of the New York International Arbitration Center, the Charter Institute of Arbitrators, and the International Arbitration Club of New York. Mr. MacKinnon has ample experience in both common law and civil law governed arbitrations, with a specific focus on Latin America, where he conducts arbitrations both in English and in Spanish. So without further ado, Ari, the floor is yours.
Thank you very much, Sebastian, and thanks to all of you who are here with us today. We're grateful to Harvard to have the opportunity to participate in this International Arbitration Conference. It's a wonderful event. And as you've just heard from Sebastian, setting aside myself, we have a wonderful panel for you today to talk about the issue of the taking of evidence in international arbitration. Now, although we're all lawyers and we've all spent years studying the minutiae of technical legal issues, and we love it, what makes us lawyers, I found that in my practice, international arbitrations often turn on the facts at least as much as they turn on the law. And you may have heard this, it's a common refrain in international arbitration that effective advocacy often requires good storytelling. And the facts are, of course, key elements of any good story. Significantly for present purposes, it is in part through the taking of evidence that international arbitration practitioners obtain the facts. Now, as all of you know, there are different approaches to taking evidence in different legal traditions. Traditionally, practitioners and commentators have divided, maybe overly simplistically, these approaches into the common law, or what I would call crazy approach on the one hand, of which I am a practitioner, and the civil law approach on the other. But international arbitrations frequently bring together parties, counsel, and arbitrators that hail from countries that may follow the common law tradition and other countries that may follow the civil law tradition. So some of the kind of vexing issues that confront the taking of evidence in international arbitration include how to bridge the gap, if there is one, between the common law and civil law traditions. Among those questions that I've thought about, and I'm sure many of you have as well, is it fair to say in the present day that there's really a common law approach to the taking of evidence in international arbitration and a different civil law approach? Or are we effectively seeing a synthesis or some sort of combination of those two approaches emerging in the international arbitration practice? These are questions to which I don't have the answer, but fortunately, we have with us today two experts who I'm sure do have the answers. And so without further ado, what I would like to do is to turn things over to Patricia, who is going to address the issue of the taking of documentary evidence. And to tee this up for you, Patricia, as someone who we've heard from Sebastian, is admitted to practice and has practiced in common law and civil law jurisdictions, I think you can offer us a very interesting perspective on the question of the taking of evidence. And I'd be curious to understand your views on whether international arbitration practice, including as reflected in the IBA guidelines on the taking of evidence, reflects a synthesis of common law and civil law traditions, or whether you continue to see two separate strands of practice, a common law strand and a civil law strand. And maybe along with that, it'd be great to get your views on how arbitrators in practice deal with bad behavior, with so-called guerrilla tactics, in which none of us on this particular conference would ever participate, but it'd be great to get your views. And so I'll turn it over to you, Patricia.
Well, thank you so much, Ari, and thanks to Harvard for the invitation. It's a pleasure to be here today and share the floor with James and with Ari. And James, I don't know that I have the answers, but I'm going to try at least to have some thoughts on these issues, and hopefully we'll all leave with some food for thought for tonight, at least, arising from this presentation. So I thought I would start, you're raising such good questions, and I thought I would start with just laying out the groundwork for, let me see, I'm not sure if you're seeing my presentation already. There you are. Great. So the first thing is, as you well manifested, it is well known there's this gap between how evidence is presented in civil law jurisdictions versus common law jurisdictions. You were raising a question as to whether the gap was actually this large. I think we're going to answer pretty conclusively that the answer to that is yes. I want to go over some of the basic traits, and I'll be very quick. Obviously, this is a simplification, but it's helpful because it helps set the framework for everything we're going to discuss afterwards when we start focusing on document production issues. So just to be very succinct, in common law, we're looking at a system where the judge is acting as a referee in pretty much what is a duel between the two parties. In search for an absolute truth, the judge is passive and the case management is pretty much in the party's hands. And the system relies very heavily on oral testimony, and it requires, and this is the important piece that we're going to focus on a lot, disclosure of both supportive documents and also adverse documents. Moving on to the civil law side, we have a system where the judge is responsible for identifying and applying the law to the facts that are proven by the parties. And the search is not for the absolute truth, but the relative truth. The case management is conducted by the judge, and the system relies heavily on documentary evidence. And the most important piece is that each party makes its case in reliance of evidence that is already in its possession. And so document requests are only admissible in very exceptional circumstances. And I want to focus on that again. To me, one of the main differences, having practiced in both kind of systems, is the amount of evidence that one may be able to obtain after the proceedings have begun that were not in your possession by the time the proceedings began. So in civil law jurisdictions, parties and their counsel are making their case with the evidence that's in their hands. In common law jurisdictions, parties are preparing to be able to reach into a pool of documents that are in the hands of opposing party, into a pool of characters, people, employees, executives that are not under their control. And so to me, the main difference is precisely this, is understanding that the how much evidence you can obtain in one system versus another, which is going to inform how parties behave in arbitration. So in arbitration, what makes this really interesting is that we're all coming together under one procedural umbrella, but all of us are bringing our cultural legal backgrounds, as well as a set of expectations as to how things should be done. And as you all know, in arbitration, the common law approach informs the conduct of the proceedings, but to a certain extent, with some limitations, and of course, not without controversy, as we will see. And that has culminated in the creation of soft law that is trying to reconcile the two approaches to how documentary evidence and other kinds of evidence is to be presented. So that takes me to the IBA Rules on the taking of evidence. The latest version is from 2020. We're looking at non-binding rules. And I'm reading from the preamble: to provide efficient, economic, and fair process for the taking of evidence. They were first issued in 1999. They were amended in 2010 and then in 2020. And they apply in commercial and investor state arbitrations. And they really reflect procedures from different legal systems. And obviously, they're useful when parties come from different legal cultures. And of course, that again is not without controversy. And I'll delve into that in a second. So when we look at document production requests, they're really becoming the norm in international arbitration. That's what we're seeing, both in cases where all parties are common law and their counsel are common law, but also in cases where we're looking at civil law parties and counsel. And the IBA, interestingly, there's the well-known criticism that it has Americanized international arbitration. I want to hold that thought for a moment until we're done looking at this, so that we think about this a little bit more, because when we're looking at the extent of discovery in the common law system, where, again, you have access to all kinds of documents, you have access to the other side's employees and executives, you do depositions. The IBA guidelines really do not provide for depositions and provide for some form of document production to a certain extent. And we're going to see that there's actually a bit of discrepancy as to how far document production may go. So I wanted to bring up Article 3, because to me, this is where a lot of the troubles begin. When we look at Article 3, and it tells us that within the time ordered by the tribunal, any party may submit to the arbitral tribunal and to the other parties a request to produce. And then it goes on to say a request to produce may contain a description of each requested document sufficient to identify it. No issues here. But also, to little I, a description in sufficient detail of a narrow and specific requested category of documents that are reasonably believed to exist. And of course, needless to say, we all have very different views as to what constitutes a narrow and specific category of documents. If you are a German arbitrator with a German background, you may have a very specific view as to what narrow and specific means. If you're a New York arbitrator and you're used to very extensive discovery in your day-to-day practice as a litigator in local courts, you're going to have a very different view as to what narrow and specific really means. So even within the common grounds that are facilitated by the IBA guidelines, in my experience, everyone has still different views as to what constitutes an appropriate amount of document production, coming under the terms as to what is narrow and specific. In practice, what I have found is that in arbitrations where all parties are common law parties and counsel also are common law, that we do have an extensive amount of document production. Obviously not as close as what we would see in US local courts, but still a significant amount of document production. Where all parties are common law parties, are civil law parties, sorry. It varies. I've seen, well, first of all, I've seen civil law parties that are just not well-versed in document production and how it works. Civil law parties that are that are practicing in international arbitration and that have become very proficient in the use of document production requests. And some of them will use it. Some of the parties won't. Others kind of try it out. And my advice is careful, because when you decide to try it out, you are committing your client to a process that can be not only cumbersome, but also unexpected for the client when it finds that it has to turn over documents that may not shed a good light on their case. And then the last piece is, and that this to me is the most controversial, is when you have parties coming from, one party comes from a common law country, another one comes from a civil law country, and then my concern there is the kinds of asymmetries that we may encounter when one party is used to litigating in local courts, is used to the exercise of document production, and the other party has never seen it. So one party has teams in place, and not only has teams in place, has strategies in place to preserve privilege. For example, making sure that there's a lawyer copied on all emails, making sure that a legal question is asked, making sure that every document is labeled as privileged and confidential. And a civil law party may not just be ready for this at all, and then may have to find itself having agreed to the use of the IBA guidelines, again, turning over documents that they're not comfortable with turning over and that they never expected they would have to turn over. So this is an issue, in my view. In any event, as a result of the gravitational pull of the IBA guidelines and the fact that some practitioners thought it was very Americanized, again, before I move on to the next point, whether it's Americanized or not, in my view, it seems like when I speak to civil law lawyers, they found the document production exercise very taxing under the IBA guidelines. When I speak to common law lawyers, they find they don't have pretty much the tools that they have in local courts. So ultimately, when everyone's complaining, it makes me wonder if probably this is actually finding some middle ground. But as I was saying before, because of the gravitational pull of the IBA guidelines, a task force put together what is known as the Prague Rules, the rules on the efficient conduct of proceedings in international arbitration, as a counterpoint to the IBA guidelines. And what we're really looking is a set of rules which is much more geared to the civil law approach as to how evidence is collected, a set of rules that gives a lot more of a visible role to the judge. The judge actually has a very proactive role in the gathering of evidence and establishing the facts. It also establishes that judges know the law, and so iura novit curia, so there wouldn't be discussions with respect to that. It provides that tribunals may help with parties reaching a settlement agreement. And going back to the issue of document production, it actually discourages any form of document production. It provides that only in exceptional circumstances, parties may request for specific documents, but they have to have announced it at the case management conference. So we're looking at a very, very different approach. I personally have not had a case yet where I've seen the Prague Rules in place. They're relatively recent, so I'm wondering if parties are starting to perhaps you put them in their contracts, and have not seen controversies arising out of contracts that included the Prague Rules or any tribunals ordering them. But I think it's a wait and see approach at this point to see how much success they're going to have. Another interesting aspect to the document production exercise is the fact that this is breeding grounds for what we call guerrilla tactics. The parties are, under the IBA guidelines and under many different sets of rules, are to act in good faith. But as we all know, even though no one in this conference has ever done this, parties tend to engage in guerrilla tactics that are designed to delay, perhaps, and also obstruct the proceedings. And one way to do this with document production requests is by engaging in a fishing expedition, for example, or responding to document production requests that are made by the other side by producing thousands and thousands of documents and trying to bury the incriminating evidence in an overwhelming amount of documents. So the IBA rules lend themselves, or actually any time that some form of document production is allowed, it lends itself to potential misuse. I wanted to show an image. This is an image from the movie Dark Waters. I don't know if anyone in the audience has seen this. It's about this guy at a law firm that takes on a case against a chemical company, and his firm is not very keen on him taking the case, but he does anyway. And so the very well-equipped lawyers from the other side send him an overwhelming amount of documents, obviously with the aim of hiding the smoking gun, which he ultimately ends up finding in the movie. So I just wanted to show that to see, because probably most people in the audience have seen this. I don't know if we have a lot of civil law lawyers, but we all see it in movies when boxes come in to law firms, or when people are buried in conference rooms dealing with hundreds and hundreds of boxes. So that's the product of a very extensive exercise in document production. How do we counter that as arbitrators? Well, there's a number of things that arbitrators can do. And it may be advisable to issue a document production procedural order with, and I'm just going to suggest a number of things that I've seen. This is I've also seen this in a model that is used by a very renowned Spanish arbitrator, where one of the proposals is, well, maybe the parties should be invited to limit the number of requests that they may do, number one. Number two, when it comes to narrow and specific categories of documents, to lay out in the procedural order exactly what is meant by narrow and specific. So do you have to identify who the issuer is? Do you have to identify the time frame very, very carefully? Do you have to give evidence of the putative existence of the category of documents that is being requested, for example? And then to lay out that any documents that do not comply, any requests that do not comply with these instructions will be rejected in limine, so that parties know what they are supposed to do. In the model that I've seen, there are also examples as to things that would be rejected. And to give you an example, something like, which is something I've seen in many different cases, all documents and any correspondence exchanged internally or externally between the claimant and any of the entities in its group structure in relation to the construction of X. Okay, so this is something that would not fit the requirement of being narrow and specific. You can also tie down what is supposed to be relevant. So, for example, asking the parties to identify the paragraphs in their submissions for which the evidentiary evidence support is required. So all of these are different tools. And of course, one that always works because money talks, as they say, is to provide that there will be a decision on costs where the tribunal may make a special allocation with respect to a document production exercise, where it will take into account the reasonableness of the requests and the objections, the willingness of the party to produce documents, and the relative successes of each party. And that might be a deterrent to certain kinds of behavior that we often see in arbitration. Moving on to the last topic, really, is the fact that in arbitration, as we all know, arbitrators do not have coercive powers, so we cannot force the parties to produce. So what happens then? I get asked this question quite often. What happens then in the event of non-compliance? What are the consequences for failure to comply? And here there are a number of options. I'll go from, and there's really no order, but the obvious one is, well, maybe the tribunal will then treat future evidence with a degree of skepticism if the party has if the tribunal has ordered a party to produce something and the party has just flat out rejected the order without satisfactory explanation. We could also do adverse inferences, which I'm going to focus on in a moment. And we can also use costs as a deterrent. So if a party does not comply with an order from the tribunal, query as to whether the tribunal may then want to sanction that party by imposing a higher amount of costs or a higher percentage of costs than it would have otherwise done. Turning to the issue of adverse inferences, which I find quite fascinating, the IBA guidelines in Article 9.6 tell us that if a party fails without satisfactory explanation, and here again, what is satisfactory explanation? It's a good question. To produce any document requested in a request to produce to which it has not objected in due time, then the arbitral tribunal may infer that such document would be adverse to the interests of that party. Well, a question also as to what adverse means, but there are times when the tribunal has made an order, the party has refused to comply with the tribunal's order, and then the counterparty says, tribunal, you should make this inference. The first question that should come to mind is the content of the inference, does it directly correlate to the non-produced document? And I've had this, I've seen this in my cases where the content of the inference that one party is asking for is tangentially related to the document that has been requested, but doesn't go exactly to the point of the document. And so that is the first item that needs to be checked by a tribunal. The second is, well, is the non-compliance, is it binary or is it non-binary, in the sense of, is it a yes or no? Can I just say, well, the lack of production, I'm going to infer A or B, or are there other options as to things that I could infer, and it's actually A, B, C, D, E, and all in different degrees of how damaging they are. Just to give you an example, let's say that a tribunal has requested a party to produce board meetings, and in the board meetings, there's an acknowledgement of debt. The counterparty is saying, I want you to infer from these board meetings that the debt that was acknowledged is in the amount of 100 million and to be paid in these terms. So sometimes parties go much further, asking for adverse inferences that contain an amount of detail that may not necessarily be susceptible of an inference, because the inference is non-binary in that case. And then my last point is, well, okay, we are in a position to make an adverse inference. The adverse inference correlates directly with the content of the document. It's binary, or at least I'm comfortable that it's of many different options. Perhaps I've seen counsel do this before and say which one is the least damaging. At least tribunal take this option as the adverse inference. Well, then what can the arbitrator do with that? And can an arbitrator rule solely on the basis of an adverse inference? And here the question is not a question of admissibility, it's a question of the weight that the arbitrator should give to that piece of evidence. And an adverse inference is not direct evidence, it's indirect or circumstantial evidence. And therefore, the question there, the most important question is this piece of circumstantial evidence enough to discharge, for the party to discharge the burden of proof? Obviously, that's a question that is, the answer to that is based on facts and circumstances. There may be instances where, without any other circumstantial evidence on the record, that may be enough. Tribunals tend to, solely on the basis of an adverse inference, I have not seen tribunals typically go ahead and assume that the adverse inference itself, in the absence of corroborating evidence on record, on the file. So that's something to keep in mind. What would be enough to discharge the burden of proof? I was faced with an issue like this not that long ago, and then different standards will apply. The adjudicators have to figure out, is this adverse inference enough to make me, let's say we're in a jurisdiction where the standard is having the intimate conviction that something happened, or if it's a balance of probabilities, is that piece of circumstantial evidence enough to get you over the threshold? And that's, like I said, that's a question of weight, not a question of admissibility. And it's something that arbitrators must do, not go straight into making the adverse inference, but rather, or actually making the adverse inference, but giving the adverse inference the appropriate weight. And then the last point is that, of course, due process is extremely important. And the party against whom the adverse inference is being made should have an opportunity to make any allegations it deems appropriate. Again, in general, in my view, tribunals are not inclined to deem a fact as proven on the basis of an adverse inference alone. And so with that, that takes me to the end of my presentation. Thank you very much. And I look forward to any questions that you may have.
Thank you, Patricia. Thank you very much. That was a great presentation. I have to say, the picture you showed of that room full of boxes brought me back to my days as an associate. It's also a recurring nightmare that I have, waking up in a room such as that. So I don't thank you for that, Patricia. Now, I'd like to maybe turn it to you, James, and I'm curious to see if you have any reactions to Patricia's presentation. And maybe one thing I can tee up for you is the question as to what your experience has been with issues arising from a party's non-production of documents.
Thanks, Ari, and thank you to Harvard, to Karim and Sebastian for the invitation to speak. I too have nightmare memories of being in that same room, possibly a different room than you, Ari, but maybe we can get a group discount on therapy for our associate memories. So yeah, let me quickly make a couple of comments on a party's non-production of documents. It's interesting. I agree completely with Patricia. Adverse inferences are tricky. In my experience, they are hard to craft in a way that really addresses the non-production, and it's very rare for them to result in either an affirmative factual finding or a finding of liability. And so I find them a very blunt instrument to deal with that particular problem. The other remedies that you mentioned, Patricia, are more common in my experience. Costs, if you really can tie it to the non-production in some way that can be quantified. One you didn't mention, but is sort of obvious, is timetable impact. So if you do come up with an argument, you've been prejudiced by the non-production of a document, and you have subsequently found some document or some source of material, then the tribunal may try and address the issue by curing the prejudice by giving you some timetable advantage, which is another way of addressing it. And I guess, but the real penalty is, and what keeps the system honest, is that if you are found to actually have had a document and not produced it, then the credibility impact is obviously very extreme. That's the real big stick that keeps the system honest. And one observation I'd make in that respect, more wearing my arbitrator hat now, is that parties have become a lot more aggressive in making claims of non-production as the technology around document analysis and artificial intelligence and data review has become more advanced. And so you can do these deep dives into the web, or looking through social media, or using software applications to produce a chronology which shows gaps where there should be documents. Those sorts of tools have led to more of these sorts of applications, and I think it's an area where there's sort of mutually assured destruction that makes sure, quite apart from rules of professional responsibility, that the lawyers do their utmost to make sure that production is made properly. So those are a few reflections.
Thanks very much, James. I appreciate it. So maybe now I'd like to change topics to talk about some issues relating to the taking of expert evidence, or to expert evidence, and turn to you, James. And as we all know, expert evidence often plays a key role in the resolution of international arbitrations, or at least we think so, because we always use experts in our international arbitrations. Keeping with some of the themes that Patricia has touched upon, I'd like to get your views on the extent to which the standards in expert evidence represent sort of a mix of common law and civil law traditions. And I'd also be interested in hearing your thoughts on recent initiatives we've seen to improve the handling of expert evidence, and perhaps on the impact of remote hearings on the presentation of such evidence. And I think, James, I told you 250, but we're fine to go through 255.
Okay.
I'll turn the floor over to you. Thanks, James.
So thanks, Ari. And I do have a presentation, which I think the moderators will put up now. So I'm afraid I don't have any of the answers to the existential questions that you started off the session with, Ari, in terms of the divide between common law and civil law, and if we're looking at synergies or something else. I will say that, picking up on something Patricia said, with respect to expert evidence, I think it is an issue in which the standards that commonly are applied, or the best practices, have just enough of an influence from the common law and civil law world to keep everyone unhappy. And so in that respect, you can say, do we need to change anything? And my submission today is that yes, we should change things, although looking at it from a common law versus civil law prism may ultimately not be the best way of trying to make those changes. So if I can go to the next slide, I'll talk a little bit now about some of the transnational standards. And Patricia has already set this up by introducing the IBA rules and the Prague rules. With respect to the IBA rules, they seek to strike a balance between expectations of common law and civil law practitioners. They are neutral as to whether to use a party-appointed expert or a tribunal-appointed expert. They provide a very sort of high-level, broad brush framework for each of those two scenarios. And they provide some basic rules for appointment of experts, minimum standards for reports, and an expectation that the expert will be presented at the hearing with a presumption, at least, about the possibility of cross-examination. So you can say that they may reflect more of a common law influence, but they're certainly a long way from what a US litigator would expect to see with respect to expert evidence. For example, the absence of depositions and some of the other aspects of US litigation around expert testimony, including broader scope for impeachment, tighter rules on qualification, those kind of things. Now, the Prague rules, as Patricia said, were sort of set up to, as they say in the introduction, to address a perceived imbalance in being too common law oriented. The main differences to the IBA rules with respect to experts are that there is a presumption that if there is to be expert evidence, then it will be a tribunal-appointed expert, although it does not preclude the possibility of there being party-appointed experts as well. I think most importantly, there is a very strong influence in the Prague rules for a more proactive management of the case by the tribunal. I'm going to come back to that in a second. And there's no presumption of cross-examination. And as the rules say, this is more consistent with an inquisitorial approach. Now, those sort of competing versions of the transnational rules have been added to over the years, and most recently, I've listed at least 3 institutional reports, notes, and protocols that have come into effect. I won't go through those in detail. I'm going to, in a moment, suggest what some of the underlying criticisms of expert evidence are that those notes and protocols are intended to address. But generally speaking, all three of those protocols on the board on the screen encourage the parties to consider using tribunal-appointed experts, proactive case management, early exchanges of expert evidence, seeking to find common ground or common scope of expert evidence. But none of them go so far as to be prescriptive. They really are suggestions as to what may be best practices. So let me go to the next slide. And I'm going to suggest here, these are some of the 5 most common complaints one hears about expert evidence. So first of all, there's this: should you have a party-appointed expert or tribunal-appointed expert, or both? And in my experience, it is, in the US at least, most typically party-appointed experts only. It is rare that there is a tribunal-appointed expert, and if you do, then it's usually an addition to the costs and potential delay, because it's really another layer of expert evidence. But what I'm going to suggest in a moment is that we might look to other forms of arbitration where it is more common to have tribunal-appointed experts have a much larger role in the proceeding. In sports arbitrations where there are doping aspects, for example, it's common practice to have a tribunal-appointed medical officer. There are other sorts of commodities arbitrations where it's typical to have an expert address certain detailed quality issues that may impact a party's claims. And so maybe we can learn from those other sorts of specialized arbitrations. I'd also suggest, because I'm going to say in a moment, that much of the criticisms of expert evidence come down to the tribunal's unwillingness to really grapple with the detail, or to put it more sympathetically, they get thrown a lot of very complex information very late in the process. And so one suggestion is that, at least in those cases that warrant it, based on costs and complexity, a tribunal-appointed expert may take some of the burden off the tribunal in trying to grapple with the information being provided and narrow down the issues so it can be presented more effectively in the final evidentiary hearing. Second bullet point, narrowing the scope of disagreements. We've all had cases where, at great expense, 2 competing experts are put on, and they're like ships passing in the night, apples to oranges, whatever the correct analogy is that you want to use. Even with the most detailed of procedural orders, I've had that happen, and it's frustrating for everyone, the arbitrators, for counsel. It can just be a strategic ploy to try and muddy the waters. Sometimes it takes the form of being an overly complex approach to expert evidence. I had a case not long ago where the other side had 10 experts addressing atomized issues, which we addressed on our side with 3 to 4 experts. Or similar, or differently, but the same point. It can simply be different methodological approaches where, even though you have the same scope of testimony, you've taken such a different approach to it that it just doesn't gel. The third point is unnecessary expert evidence. An example of that would be, do you really need to have the experts on the law? Some cases you do, but there are cases, a lot of cases I've seen where that's not necessary. The fourth criticism is to do with a lack of tribunal engagement. And as I said a moment ago, I think much of the inefficiencies come about because of the difficult position the arbitrators are in trying to process complex information. Things like hot tubbing really only work if the tribunal really understands the evidence that's been presented with. And then lastly, sort of a catch-all of techniques for controlling time and costs. Many of the same criticisms that apply to document production as Patricia talked about, bulky reports, extensive document requests, unwieldy presentations in the actual hearing. Those are things which just add to time and costs. So if you go to the next slide, this is where I get to my non-panacea, but some suggestions of what we could do that moves beyond the sort of modest suggestions and the protocols that have come from the institutions. And my proposal is that, having lived through and hopefully now beginning to come out of the COVID pandemic, we're all very happy to be going back finally to in-person hearings. I had my first one this week since 2 years. But we have learned during the pandemic to deal with remote hearings and to adjust how we present cases. And I think there are some lessons we can take away from that and carry on with in the post-COVID world that can be applied to the expert evidence scenario as well. And so I've got 5 suggestions on the screen there, which I'll talk about a little bit. So first of all, case management conferences. Now, even since, I guess, the ICC report on time and costs and the ICC note, there's always been an emphasis on the initial case management conference, the need to expand the issues that are addressed in that conference so that the tribunal can start a discussion about what the real contours of the arbitration look like. And so I have a discussion of expert evidence on my standard agenda for a case management conference. I will often be presented with the not unreasonable response from the parties that they don't know yet what that will look like. If that is the answer, then I think you need to have a follow-up conference sometime later on to make sure that the experts have really engaged on the issues to avoid that ships passing in the night scenario. And in that respect, remote hearing technology just makes case management conferences easier. It's just it's an easy cost justification to schedule a subsequent conference when you really dig into the expert evidence. At least there is a naming of experts early on, or a fairly detailed scope of what that expert will address. And the arbitrators should have a hands-on role in that, in my view, rather than simply leaving it to the parties. Second point, tribunal-appointed experts. Now, there are lots of concerns people have about tribunal-appointed experts, but one of them, I think, is just a fear of the unknown. So in the few cases where I have had tribunal-appointed experts, we've had to adopt some protocol for identifying the experts, joint interviews, or a list of questions that are agreed in advance, things like that. Again, remote technology can make that a more efficient process. You can have joint interviews of potential candidates. You can interface more easily with organizations like the ICC or industry-based groups that specialize in providing experts to dispute resolution proceedings. So again, think about employing those tools to make that an option. And then a large bullet point here: expert meetings, joint reports, and Kaplan openings. This is all common territory. I'm not suggesting anything new, but video conferencing simply makes these things easier in terms of the expert-to-expert conferencing, in terms of updating the tribunal on the status of expert issues, and even at the more extreme end of the scale, a so-called Kaplan opening, which I have seen done effectively in big, complex, particularly construction cases, where you have a sort of mini hearing where the parties put on a preview of what will come in the evidentiary hearing, but particularly focused on expert issues to make sure that they really have joined issue. And here again, video technology can make that easier and cheaper. So I can see a future in which the Kaplan opening is a standard procedure that happens in the cases that warrant it, at least, where it's done remotely in advance of an in-person evidentiary hearing. And as part of that, I'd also point out that there can be greater use of technology with respect to expert evidence. So it could be as simple as using Google Docs, which my kids use for all their collaborative classroom homework. Using that Google Docs for producing joint reports or a Scott schedule or those types of joint efforts between the experts. It can be more complex, like agreeing parameters and then using a software platform to share those parameters for finite element analysis in the engineering world. Or it could be something that actually impacts the hearing itself and how experts present at the hearing. Ari mentioned the need to be good storytellers. And one hopes that experts are part of that storytelling. And I think we've learned during remote hearings and COVID that you can use visual aids to do that in a very effective way. And I think lawyers have been somewhat slow adopters in that respect, but there's more to be done with that with expert evidence. And lastly, I've just mentioned the potential role for experts after the hearing. I think we've all been in cases where, counsel with a sigh of relief, file their post-hearing brief and then, sort of, burn their materials and wait for the award to come down. But the arbitrators are often left with complex issues, often around damages, for example, where they are being asked to assess the evidence and apply it in a way to produce the final award, and mistakes can happen, or it encourages conservatism. And so I think we can think more creatively about producing joint Excel files with formulae that allow for particular variables to be decided by the tribunal depending on the liability decisions that are made. To take one easy example, or as I think I've seen, and I don't think it's unusual these days, there's an agreement that the tribunal is able to speak jointly to the experts prior to issuing the award to ensure that their award is consistent with the evidence that was presented. So I'll just make a couple of concluding remarks now, and they sort of follow from what I've said previously. We're all glad to be returning to in-person hearings now, but my suggestion is that we should take some of the initiatives for remote hearings and apply them to best practices, to move those best practices forward, whether you see them as common law practices or civil law practices. It's really about making the arbitral process more efficient, and avoiding the pitfalls of expert evidence and trying to mitigate some of those criticisms that I listed previously. So with that, I'll end it there.
Thanks, James. That was a very interesting presentation, very refreshing take on how we can try to take some of the lessons learned and move forward with them into hopefully return to our in-person practice. The example you mentioned of the experts perhaps being asked post hearing to get together and work on an Excel spreadsheet or some sort of damages model. Interesting that you bring that up. I just had that happen in a Sao Paulo seated arbitration that we worked on. And although we were initially aghast that the experts were going to be talking to one another outside of our presence, and the lawyers need to be there, of course, and make our arguments, it worked out, I thought, pretty well. So maybe Patricia, before we conclude, I did want to get your reactions to James's presentation, any aspects of it. But one particular question that I was hoping to ask you was about the practice of your experience with the practice of so-called expert hot tubbing, which I think James mentioned, and whether you have found that practice to be useful in your experience.
Thanks, Ari, and thanks, James, for the very useful presentation. And I agree, we need to take some of the lessons that we've learned for the past 2 years and apply them and leave behind the two camps, common law, civil law, and just move into what's really a best practice. When it comes to hot tubbing, I also agree with your statement that it works when the tribunal is engaged and when the tribunal understands what's being presented to them. That, of course, means the tribunal has done its homework. I find that in the cases where I've had it has helped to narrow and crystallize the issues. I find that when the experts are interacting with each other, they show less bias. I think the fact that they have a colleague sitting right next to them that can opine right there and contradict them helps contain the I'll call it the hired gun effect that we see sometimes. No, of course, no one in this presentation, but that we sometimes see when they have somebody there to keep them in check. And so I think that's something that really works out. The other aspect that works really well is, and going back to the image that all of us related to, that thought was so painful when we saw the boxes, when you're preparing for a cross-examination with an expert and somebody tells you, oh, you go in, you punch, you get out before you get punched, because it's very hard to cross someone on their area of expertise when it's not yours. How do you engage on the substance of their report when you're not an expert in LNG, you're not an expert in mining, you're not an expert in whatever it is that's the highly technical field. So I have found that having the experts there at the same time, they are better placed to challenge each other's views. And it turns out I find there are more areas of agreement when I've had hot tubbing than what would appear otherwise from their initial reports. So I think overall the exercise helps the adjudicator make better decisions. And I think in the right circumstances, it could be a useful tool to be considered.
Excellent. So thanks very much for that, Patricia, James. And I think with that, I think this wonderful panel comes to a conclusion. I don't know if I'm happy for Patricia or James, if you have any concluding remarks you'd like to add. Same for you, Sebastian, Karim, but this has been a wonderful joy for me to participate in this panel with all of you.
I just want to thank Sebastian and Karim for all the work that you've put in for the annual conference, and to all of the High ELSA team that's also working on this. Good job, and thanks for the invitation again.
It's just to add my bit. It's been very impressive what I've seen so far, and there's more to come tomorrow. So congratulations to the ELSA team.
Okay, thank you very much to all of you. This was a truly fantastic panel. Now we're going to have a really short 10-minute break, and we'll be back in 10 minutes with the final keynote of today, Mohamed Shelbaya's keynote speech. Thank you very much.
Good afternoon or good evening, everyone, and welcome back to the 8th Harvard International Arbitration Conference. Our second co-chair and last co-chair for the day is one of the founding partners of Gaillard Bani Fatemi Shelbaya disputes, Mr. Mohamed Shelbaya. Mr. Shelbaya is trained in French, English, and Egyptian laws, and is recognized as a leading figure in arbitration, with a particular focus on arbitrations in the oil and gas sector. Mr. Shelbaya has represented companies, states, and state-owned entities in more than 60 commercial and investment treaty matters, including many multi-billion-dollar disputes involving novel questions of international law and geopolitical issues. Mr. Shelbaya also regularly acts as arbitrator in both commercial and investment arbitrations and teaches investment arbitration at Sciences Po Law School in Paris. Today, he will be talking to us about how international arbitration stands between legal cross-pollination and legal acculturation. Mr. Shelbaya, the floor is yours.
Let me first start by thanking the Harvard International Arbitration Law Students Association and Sebastian and Karim for organizing such a well-structured and substantive conference and for inviting me to participate in it. And we also thank Arbitration Channel for making this possible despite the obstacles the pandemic has imposed on all of us. Hopefully we get to all meet in person very soon. It's really truly a pleasure to address you on the sort of common law, civil law divide and arbitration's contribution to either making it bigger or smaller, and we'll sort of address both sides in what I've chosen to call legal cross-pollination and legal acculturation. So let me get right into it. Well, first of all, just some terminology, right? What do I mean by legal cross-pollination and legal acculturation? Cross-pollination, as you would know, is a biological sciences concept. It's essentially where pollen from one plant is transferred to the stigma of the flower of another, thereby promoting biodiversity, genetic diversity, and essentially benefiting both. Right? For the purposes of this presentation, legal cross-pollination is where a legal system appropriately and harmoniously adopts a process or a concept or procedure from a foreign legal system. And of course, that begs the question of what is harmoniously? And at least to me, that means two things. On the one hand, it means respecting the purpose and the mechanism that you're importing. So understanding it in its full spectrum and taking it without distorting it. But then also, the second part of it, it means when you're importing it, that foreign concept, you are making it fit within the fundamental principles of the importing legal order and making it fit with the other processes, concepts, and procedures that exist within that system. So there's no clash. Now, an example of a harmonious incorporation and therefore of cross-pollination is how some civil law systems have imported the concept of estoppel from some common law systems, and we'll get to that and other examples. On the other end of the spectrum, you have acculturation, and acculturation, now we're outside of hard sciences and now we're in sort of social sciences, and at least in some of its acceptations, it is meant to convey the process that occurs when two cultures previously isolated interact, and usually with a negative connotation, because usually the interaction is not, let's call it voluntary. It's usually in the advent of like colonization and things like that. But the point is that you get two cultures that clash when they meet rather than incorporate harmoniously. Now, for the purposes of this presentation, legal acculturation occurs when a foreign legal concept is misinterpreted or inappropriately incorporated by the relevant legal order. An example of this, and a quite typical one, is the use of common law concepts such as fraud or liquidated damages even in civil law contracts, which happen quite often. And again, we'll get back to it and we'll see more examples. Our general point is that arbitration doesn't cause any of this. It is not the cause of this, either the positive or the negative, the cross-pollination or the acculturation. It's merely a catalyst. And like any catalyst, in speeding up the process and accentuating the process, it sheds light more clearly on its advantages and its problems. And we'll also see how each time arbitration contributes to that. Now let's start with the positive, right? So, and the positive being what I'm calling the cross-pollination in international arbitration. Now, the cross-pollination can happen in many ways, but I chose three to highlight. One is as banal as importing foreign procedures, and this is something most of us would have seen quite a lot. More interestingly, it happens when importing substantive concepts from one legal system to another or from one tradition to another. And then finally, that's less importation, but it's rather when each legal system construes concepts that are their own, public policy, approach to contractual construction, in a way that takes into account how other legal systems have approached it. So sort of trends toward uniform construction of flexible concepts, if you will. That happens within the New York Convention, but not necessarily, sometimes nothing to do with the New York Convention. So those are the three sort of typical means of legal cross-pollination that I wanted to highlight. So let's start with the first, importing foreign procedures. Again, you would have heard about this a lot, so I'm going to go quite quickly on it. Document production being, discovery being the sort of hypothèse d'école, the sort of the stereotype that is usually used to portray this phenomenon, because civil law system either did not know it or had it, but it was not used. It's not true that that it doesn't exist. It exists in some forms. It's just A, limited in scope, and B, rarely relied on in many civil law systems. But as a result of sort of cross-pollination coming from arbitration, especially, but not just, you have now document production, of course, being used systematically in continental or sort of non-common law arbitrations, where no common law lawyers are involved as arbitrators or as counsel, or English law or any other common law, applying to the procedure or to the substance, but parties still almost regularly, if not systematically, resorting to document production in order to benefit from the advantages that it procures both parties in being able to advance their case. More interestingly, not just in arbitrations, but now you have domestic courts in civilian jurisdictions doing the same. So, for example, here you have an example from the Paris Court of Appeal, a decision from April 2018, so not very old, in which the court, on its own motion, was an arbitration case, without not unsurprisingly, and the court decides to reopen the record in order to order parties to produce documents for it to assess corruption allegations that were at stake. So this is even more interesting because it's easier to import concepts or procedures through arbitration. When it happens through the local courts, it's all the more meaningful. But again, facilitated, accelerated by arbitration. Now, other ways is just simply the weight you give to some forms of evidence. So written and oral witness statements are again, not unused, unheard of in civil law jurisdictions, but the weight that's given to them usually used to be less. And now in continental arbitrations or in sort of non-common law arbitrations, you have regular and systematic recourse to witness statement, witness evidence, cross-examination in a much more sort of common law style than used to be the case, say, 50, 60 years ago, as a result of this sort of cross-pollination between cultures. conversely, the civil law style pleadings, one sees much rarely, even in purely English law sort of arbitration context, the sort of paragraph-wise rebuttal submission that when you have an example here, but now it's much more uniform. It's sort of an arbitration style. Now, one can call it a civil law style pleadings, but that's not necessarily fair. I think it morphed into just something of its own, so something sui generis. But that is more civil law than it is common law in its style of and sequencing of pleadings. Now, more interestingly, moving away from procedure, you also have the importing of substantive concepts. And I had referred earlier to estoppel, and I find the estoppel example particularly illuminating. So here you have a case from the Egyptian Court of Cassation. It's a recent case from 27 October 2020. And what's interesting there is not just the fact that the Egyptian court considered that estoppel to be part of Egyptian law, but how it did so. And how it did so is, I think, characteristic of what I would call the difference between cross-pollination and acculturation. We'll get to that. But to start the case, and again, showing the relevance of arbitration, the case arose from a party trying to renege on an arbitration agreement that it has signed based on a technicality relating to the means by which it signed it. And the court says, oh, fine, you may have breached applicable rules, say relating to authority or otherwise, when you've signed this arbitration agreement. But that error was relied on by the other party, and you cannot now try and distance yourself from it. So, the court says the party that causes by its own act a breach of the arbitration agreement, arbitration law, or other law cannot contradict itself when a second party has relied on this wrongful or behavior or act. Now, what's interesting is how the court reaches this conclusion, right? Because it starts by saying this comes in application of the universally recognized principle. Then it links that principle first to Roman law, the prohibition of contradiction to the detriment of a third party. Sharia law, because it's citing an adage after that, that is a Sharia law principle, the attempt by a party to abolish what it has self-accomplished must be disregarded. And then expressly estoppel, and it transliterates the word estoppel into Arabic. And then it keeps referring to the word estoppel, and a couple of Egyptian decisions did that by just the rule of estoppel sort of transliterated. But what's interesting is the link, because the court recognizes that there is no express rule of estoppel under Egyptian law. But then it says, but Egyptian law allows me, in the absence of an express rule, to find inspiration in the general principle, well, first in customs, and if there is no custom, then in Sharia law, and if there is no Sharia, then in natural justice and rules of equity. And from those sources of law finds that the principle of estoppel fits within the Egyptian legal system, and then gives the conditions under which it will apply. And that's why, because this is not the first decision that did that, but it's the first one that actually gave the conditions for estoppel to apply. And that's why, to me, it fits the sort of the conditions for in cross-pollination as opposed to acculturation, because it said, there has to be inconsistent conduct has to have been relied on, and there has to be detriment. So it sort of understood the concept of estoppel properly, tried to link it to the other sort of principles and processes of Egyptian law, and not just put it in there and let the parties figure it out. So that's an interesting example to me of cross-pollination. Sometimes it's not through the courts, sometimes it's just through the practice, where the courts don't catch up, practice catches up. Now, force majeure is interesting. I mean, anecdotally, you had the Suez Canal crisis in the 50s, and courts dealt with it differently and as you know, that meant that the Suez Canal was blocked, and shippers, so say shipping tea or something from India to England, had to go around Africa as opposed to passing through the Suez Canal and the Red Sea. That, of course, was almost impossible to achieve. No general doctrine of force majeure exists under English law. The threshold for frustration was not met. So English courts just said, well, figure it out, have to enforce the contract. Conversely, around the same time, French court said, well, no, that's a force majeure, you're relieved of your obligation to perform. Post-Suez, you've had a proliferation of English arbitrations relating to some more sophisticated force majeure clauses, and then the evolution continued. But what's notable is that the practice in common law jurisdictions in drafting force majeure clause, it almost mimics naturally the conditions for force majeure as they exist in French law and many other civil law jurisdictions, right? So that's cross-pollination almost through practice rather than through sort of court normative action. Third-party rights is another example. For the longest time, for about a century. Before 1861, there were some earlier sort of origins for third parties to be able to enforce rights under a contract to which they're not a party. But from 1861, since the reform of the sort of concept of consideration under English law, all the way up to 1999, so more than a century, there was very limited scope, almost inexistent scope for a third party to enforce any right, procedural, so arbitration agreement or otherwise, under a contract. And then you got the third party rights form, and in the law reforms, you have express reference to the fact that one of the reasons, I'm reading now from the report, a further factor in support of reforming the third-party rule of English law is the fact that the legal systems of most of member states of the European Union recognize and enforce the rights of third-party beneficiaries under contracts. In France, for example, general principle that contracts have effect only between parties to them is qualified by Article 1121, the old article in French Civil Code on the stipulation to the benefit of others. Interestingly, in that same statute, in the Right of Third Parties Act, you have an express provision that says that the third party is bound by and is able to enforce the arbitration agreement that might exist in the contract under which that third party has rights in enforcing those rights. And that's essentially the same solution that French law had arrived at independently with respect to arbitration agreements and the relationship with third-party beneficiaries for a stipulation to the benefit of others. And this sort of, and again, this is cross-pollination rather than acculturation, because the rule is understood in all of its ramifications, is brought into the system and made to fit with the other parts of that system. And I mean, now that the UK is no longer a member state, I very much doubt that rule will change, even if it was justified by in part by the rules of other member states, and that in part because the rule has harmoniously fit within the legal system that incorporated it. Now, the next sort of example is the uniform construction, right? So that I'm going to go rather quickly on, but it's again useful that it arises in the context of arbitration. So you have the seminal Fiona Trust case in the UK, where you have both Lord Hope and Lord Hoffman's speeches on the rule that arbitration clauses are to be construed in a common sense way, and without stopping at things like the difference between arising under or in connection therewith. Both of them reference the German approach adopted by the German courts years earlier in the 70s. Similarly, you have as some of you may know, French courts in 2000 and in the early 2005, 2006 adopted a rule by which French courts are allowed to act in support of an arbitration not seated in France by appointing an arbitrator in lieu of party that is defaulting, or that has refused to appoint an arbitrator, if there is some connection to France, however tenuous, sort of on the basis of universal right of universal jurisdiction. Essentially, it's not really universal jurisdiction, but quasi-universal jurisdiction. And you have the Singapore courts a few years later doing the same, well, a decade later, doing the same by express reference to the French rule. And again, the way the court justifies why it's doing this and the reasoning and how it fits within the other parts of Singapore law is why this is cross-pollination as opposed to acculturation. So you have the court saying, although this reasoning emanated from a civil law jurisdiction and drew support from European human rights law, its fundamental logic appears to be sound and consistent with Singapore public policy. While it would not be open to a Singapore court to adopt wholesale the reasoning of the French courts, in particular one based on European human rights law, I am of the view that such a decision could be justified either on the basis of contract law, Singapore contract law, or an exercise of the court's inherent jurisdiction to prevent injustice. So the concept is taken and it is sort of placed within the legal order of Singapore in a harmonious fashion. Now that's the positive. Now let's take a quick look, not so quick look, on the negative. So on acculturation, on examples of what I would call acculturation. Now that can happen in many ways. 3 ways that I would like to highlight. I think we're only going to have a chance to get through 2 of them. Is acculturation as a myopic application of the applicable law, and by that I mean when essentially the tribunal applying the applicable law reads it through its own legal culture, or as confusion of foreign legal concepts. Now, myopic application. This is essentially where you have a sort of common law trained tribunal applying civil law as if it was English law, or a civil law tribunal applying English law as if it was French law or some other civil law. Now, what sort of, and you can see this at very many levels of abstraction, right? If you take the first most abstract level, there is at least stereotypically speaking, there's a difference in approach to legal construction between, say, the civil law system that adopts a quasi-subjective, is not really subjective, but a quasi-subjective approach to interpretation, where the actual goal is the intent of the part, is ascertaining the common intention of the parties, and the language of the contracts is just one important, but just one of the elements you take into account to ascertain that intention. And the more objective English law approach that is just about construing the objective meaning of the terms and what they reasonably mean, but ultimately your sort of 4 corners of the contract are your beginning and end. That is, I think, a vulgarization of both approaches, to be honest, but it's a useful proxy for the actual 2 approaches. And there are consequences to that philosophical difference, right? You have the parole evidence rule applied in common law, but not civil law systems. You have subsequent conduct used as an interpretive tool in civil law, but not in common law systems. And then you have tribunals, and trouble comes when you get a civil law tribunal refusing to accept that this is English law, and that when you apply it, you have to forget your reflexes and adopt the reflexes of the applicable law, because it's not just applying the rule, it's how you apply it that sort of makes the difference. Or the reverse, where you have a sort of common law tribunal applying civil law, but still refusing to sort of switch gears philosophically in how they approach the relevant norm, contract or otherwise, as before them. So going down the level of abstraction to something a bit more concrete, it sometimes manifests this myopic application of the applicable law in a reluctance to apply certain concepts from the applicable law. Good faith, which you would have heard an interesting discussion this morning, is a good example. Famously or infamously, English law does not recognize a general doctrine of good faith. That's not me speaking, that's the English court speaking. And I'm quoting, and such term is unlikely to arise by way of necessary implication in a contract between 2 sophisticated commercial parties negotiating at arm's length. In other words, there is no general duty, statutory or otherwise, of good faith. And it's not a term that one implies by necessity in all contracts. Some contracts under English law, this would have been found to arise in them, say long-term joint ventures, partnership agreements. But despite that, you get, well, not often, luckily, but sometimes you will get a tribunal applying this law, but it's not from an English law background, so say a civil law tribunal. And so you have a hypothetical award here, anonymous awards rather than hypothetical, in which a tribunal constituted of civil law practitioners applying an English law contract and deciding on termination under it. And you have the tribunal saying that the termination breached the implied obligation of good faith under the agreement, but no such one exists, right? And that's the myopic application of the law. And the problem with that is not necessarily just the fact that the rule is wrong, right? There is no implied duty of good faith, or that there is one. The problem is much more systemic because, and the issue with acculturation generally, as opposed to cross-pollination, it's not that particular rule, good or bad, is being imported or not. The problem is each legal system has its own ecosystem. It is the very illustration of the whole being bigger than the sum of its parts. It's not just a collection of rules, it's how these rules interact together. And they're usually, when the system is well designed, they tend to be complementary to one another. So the objective interpretation rule is actually philosophically somewhat linked to the lack of duty of good faith, general duty of good faith, itself somewhat linked to, say, liquidated damages being enforceable as per their terms, regardless of actual loss, and without possibility to moderate them if they're not penal, and so on. And conversely, civil law system has its own sort of equilibrium and justice and genius, and you disrupt that if you take one part of it but not the other. The quasi-subjective, quasi-objective approach to interpretation, together with the general duty of good faith and what it entails in terms of added obligations of the contract, together with the possibility to have a penal clause, but one that you can moderate, it all fits together as a whole. And the real problem comes not from one rule, but comes when you take one of those rules away or add to it without seeing how it fits with the rest. Now, another example is, say, just complete disregard of formal requirements under the applicable law. So it works both ways, not just a civil law tribunal disregarding English law, you also have English law tribunal disregarding civil law. So that's an example of, in Qatar, some other civil law jurisdiction, especially in the MENA region, there is a requirement that comes originally from French law, but that French law has since let go, but still pretty much solidly part of the laws of the region, is that you cannot terminate a contract without going to court. And the only way to do that without going to court is to have an explicit, not just clear, but an explicit, essentially, rule clause in the contract allowing you to do so. And you have plenty of cases. So in that case, for example, you have a case expressly just saying the mere existence of a clause in the contract that says you can terminate without breach, or without in case of breach, full stop, doesn't mean that you can do so without a court order. That just means you can terminate. And the judge will then have to order termination. It doesn't become a question of discretion. But you still have to ask it from the judge, unless the contract says you do not have to go ask it from the judge. So the tribunal in that case, English law trained, looks at this and says, yeah, okay, I see that the court says that, but be that as it may, I look at the agreement and it categorically and clearly provides that you don't have to go to a court because it says you can terminate by notice. That's clear enough. But that's not how the local courts have consistently applied it, right? And again, there is an equilibrium to the system. It may be one you don't like. I personally find this rule rather odd, but it is there. And as long as it is there, one has to follow it because, again, there is an equilibrium to it. So the consequences of termination under those particular jurisdictions are much more drastic. There is a presumption of retroactivity, for example, that does not exist under English law or even under French law in most cases. So again, it's not a particular rule. It's the whole ecosystem that gets disrupted when these things happen. Now, it's not always a problem of tribunals. In fact, most of the time it's not. Most of the time it's counsel that creates this acculturation. And now let's get to examples of acculturation through acts of counsel, not acts of decision makers. Now, this happens when you get a contract drafted either with a sort of civil law background, but then subjected to English law, or frequently, to be honest, in practice, much more frequently, drafted with a common law mentality, but then subjected to a civilian legal system. And that arises in its disruptive effect, right? Because you have parties thinking they're saying one thing and they're agreeing one thing, but then end up the consequence that the contract meaning something else because of the applicable law. Say consequential loss. So typically you'd have an exclusion of damages or liability that says that the defaulting party will not have to pay consequential loss. Right? But what does that mean? If you take it as just plain English, you might think consequential loss means indirect losses, and that means something under a civil law. So let's say this is a contract governed by French law. Right? Indirect losses are something else, and they're not usually recoverable anyway. But if you take it in the legal jargon sense, this not being a French law term, but an English law term, and what it means under English law, it may very well exclude lost profits, even some of the direct lost profits. And you have Hadley and Baxendale on that. And that becomes a much bigger problem, because if the parties didn't mean to exclude lost profits when they referred to consequential loss, because they were not referring to it in the English law sense, then that becomes, and they end up with an exclusion of lost profits. That's a massive disruption to the economic bargain that's at stake here. And that happens, it can happen the reverse. So the sort of things that sound similar but are not the same is a typical problem in these sort of template contracts, or not even template, ones drafted with certain legal culture in mind that then gets in clash with the applicable law coming from a different culture. And that can have massive economic consequences. Liquidated damages and clause pénale is another one. Typically, this would come in the form of, say, a take-or-pay provision in a commodity sale agreement where the seller will provide goods of a certain quantity every month. The buyer has to either take them and pay for them, or pay for them anyway, even if they don't take them, or at least 95% of them, or so, whatever percentage. This essentially is there to ensure the seller constant stream of revenue per month or per year, or whatever, per quarter, for the duration of the contract, regardless of whether the buyer ends up buying it or not. Now, let's say you subject this to French law, or to Marathi law, or Egyptian law, or some other civilian legal system, right? This usually comes in the form like, oh, does French law recognize liquidated damages, clause pénale? Yes, it does. But are they the same thing, whether philosophically or in practice? They're not. There are ways. If the point is to ensure a constant stream of revenue to the seller, there are means within the French legal system or some other civil law legal system to ensure that, other than a clause pénale. Clause pénale is not made for that. Whereas a liquidated damages clause in an English law contract is very well designed for that as well. So that sort of, these things that sound similar but are not exactly the same cause a lot of these problems. So under English law, an LD is well, the first question you ask yourself is penal or not, and it's almost never penal. For it to be a penalty, it has to be. It used to be that it needed to have not a genuine pre-estimate of loss. It's the Dunlop precedent, but that has evolved into a new test where essentially, even if it is not a genuine pre-estimate of the loss, it's not penal unless it has no commercial justification other than to deter breach. So the only thing really that English law cares about precluding is that it's designed to deter breach. Once it's not that, then it's valid and you enforce it as it is. The civil law approach in France, the Middle East, Latin America, rest of Europe, it's very different. It can be penal. It's called penal. It's a penalty. It's fine for it to be a penalty. It doesn't become void. But, and that's why I'm saying it's an ecosystem, I'm allowing it to be a penalty, but I can moderate it if it's excessive or too little, right? And under French law, for example, you can't change that. You can't provide in the contract that, a contrary agreement. Now, in the common law world, in English law, it's the exact opposite. The whole system is designed so that proof of actual loss does not matter. They have MSc Mediterranean. The purpose and effect of a liquidated damages clause is to make proof of the claimant's actual loss unnecessary and irrelevant. Even if there are zero losses, you still get to take your money, as the seller in our example. Whereas under civil law, we saw the French article, but you also have, say, the Egyptian civil code that tells you that if you can establish that the creditor suffered no loss, you pay nothing. And that, of course, disrupts very much if that was the bargain that was intended in the start, that very much disrupt that unnecessarily, because there are concepts of alternative obligations, there are concepts that allow you to reach that result differently. Fraud is another very sort of typical example of that, because fraud, well, let's start from an example of a clause. We have a clause, an indemnity provision that's very important in some agreement. Imagine you have a well services agreement or something like that, where indemnity can be in the billions of dollars. And you carve out from the indemnity fraud. Now, whether this exclusion is this big or that big will depend on the concept of fraud is this big or that big. Problem is, if you're drafting this, say, with an English law background, you're thinking you're having tiny carve-out to your indemnity clause. But then you apply UEE law, for example. Well, under UEE law, fraud is much bigger than it is under English law. So you end up with a carve-out that's much bigger. And again, if there are ways to have achieved the economic bargain anyway under either system. The problem here comes from thinking two concepts are equivalent when they're really not. Because say fraud under English law requires you need to be making a statement or equivalent that the other party will rely on. The intent is for the other party to rely on. No such requirement is necessary under, say, the Marathi law. Therefore, you may end up with a much bigger exclusion. So again, see, it's a concept that is incorporated, but without due regard to what it means in its original ecosystem and how it fits with the importing ecosystem. And let me finish on this because I don't want to exceed my time. That can happen not just in civil law, common law divide, and that's why I want to finish on something that is sort of, you can have, it's a problem of approach, because you can have that problem even within the civil law. Mitigation is a very good example. You can have a contract, say, drafted with a French law mentality or drafted with an Egyptian law mentality, but subjected to French law or Egyptian law respectively, thinking that the same French law as Egyptian law is copied from French law anyway, it must be the same, and therefore it's not going to be an issue. And therefore, for example, you don't provide for any contractual duty to mitigate because even though you want it, but thinking you're from an Egyptian law background, thinking, well, there is a duty to mitigate under the law anyway, but French law doesn't have it. Whether pre-reform in 2016 or post-reform 2016, there is no general duty to mitigate under French law. Whereas under Egyptian law, loss is only recoverable if you could not have avoided it. Therefore, if you didn't, if you tried and failed to mitigate. So that just shows you that the acculturation can happen even within subcultures of one culture, right? And it brings me to my final point, and I'm going to skip the disruptive impact of the applicable law, say, through things like hardship. You would have heard an excellent presentation on that already anyway, a debate, on that already anyway. But my final point is one of approach, really, and it cannot stress enough that the issue is never the wisdom of a particular rule. The issue is always how two legal orders, how two cultures, how two ecosystems can be made to fit with one another, but that only happens on the dual condition that one preserves the conceptual integrity of the imported concept or process and import it in a way, that's the second condition, that respects the other existent principles, philosophical approaches, and processes of the importing system. And that happens whether in civil law, whether in common law. It happens, of course, more often in different cultures, but even within the same culture, it can happen. And with that, I thank you very much for your attention. And hopefully I'll see you all in person soon. Thank you very much.
Thank you very much, Mr. Shelbaya. It was an amazing keynote speech and an amazing way to end the first day of the 8th Harvard International Arbitration Conference. This is it for today. We will get back here tomorrow at 9 a.m. You will receive a link with the instructions to the panel tomorrow. So that's it for today. Thank you very much, everyone, for your participation, and we hope to see you tomorrow again. Thank you very much.